Hello friends, welcome back to the series of lecture. This is the 58th lecture of this series of Indian Evidence Act. And maybe by this lecture or by the another one more lecture, we would try to conclude the Evidence Act. So in the previous lecture, we had left with 167. What I have told you was, so we had seen that if the trial court done an irregularity by not allowing admissible evidence or by allowing inadmissible evidence. And what is admissible evidence and inadmissible evidence? That I expect that you already know it. But if the irregularity is if the court has not allowed an admissible evidence or it has allowed an inadmissible evidence, then the party affected goes in appeal. And in appeal he raises the ground. And in appeal he raises the ground that such a mistake was done by the trial court. Then the appellate court, merely on the ground of that irregularity, suppose suppose it is proved that the admissible evidence is not allowed or inadmissible evidence is allowed, then will the appellate court merely on that ground set aside the decree? So we had seen in previous lecture that the answer is no. मतलब आप ये prove कर दो that the error was there in either of these, then the decree will not set aside per se. The decree will be set aside only if the appellate court finds that if this admissible evidence is allowed, if this admissible evidence has been allowed by the trial court, then would the decree had been different? Means that would affect the merits of the case so materially, and the judgment would have been different. And similarly, if the court has not allowed this inadmissible evidence, then would the decree had been different. If that was the importance of evidence, that the very judgment would be different, then the appellate court will go for the set aside of the decree. Then only the appellate court will go on to set aside the decree. And we had written a paragraph upon this. Write few lines more on this. Right. The appellate court will not set aside a decree. The appellate court will not set aside a decree merely on the ground of the error by the trial court in allowing inadmissible evidence or disallowing admissible evidence. The decree will be set aside only if the error was such as if it had not been done, the judgment in the case would have been different. Now please take out section 120. It is about privileged communication. Now you see what is meant by the privileged communication. It means there is a communication between persons which is otherwise relevant and which should be therefore allowed to be proved. But because it falls under privileged communication, then the party cannot give evidence on that communication, nor the party can be compelled to give evidence on that. In this, a husband cannot be compelled in the court to tell that what did your wife communicate to you, unless there is a suit or proceedings directly between the husband and wife. So read it. In all civil proceedings, the parties to the suit and the husband or wife of any party to the suit. In all civil proceedings, the parties to the suit and the husband of or wife of any party to the suit shall be competent witness. In criminal proceedings against any person, the husband or wife of such person respectively shall be a competent witness. So that is just a declaration that can the husband and wife be a competent witness. Now you will see अगर ये नहीं भी लिखते, then as per section 118, if the husband or wife is capable of understanding the question and giving the rational answers, then one would be a competent witness. अब ये इंग्लैंड में रूल होता था पहले कि that husband and wife are considered to be a one person. Now, that rule is not applicable in England, and that rule is not applicable in India also. and therefore the husband and wife will be considered to be two distinct persons, and therefore a husband can be a witness for the wife or even against the wife. Similarly, a wife can be the witness for the husband or even against the husband. So it is only a declaratory provision. If you see again, in all civil proceedings the parties to the suit. अब दो चीजें कह रहे हैं. If civil proceedings में मान लो there is a suit between A and B, then can A be a witness? Can B be a witness? यहाँ husband and wife की बात नहीं हो रही. If there is suit between A and B, can A be a witness? Can B be a witness? अब यहाँ पर husband and wife की बात नहीं हो रही. The first part is talking generally about the parties. The answer is yes. अगर आप CPC में ऑर्डर 18 रूल 3A देखोगे तो it is clearly saying that if the plaintiff wants to be a witness or the defendant wants to be a witness in a case, then he shall appear as the first witness. Means that is clearly saying that the plaintiff or the defendant can be a witness for themselves in the civil proceeding. अब उसी बात पर यहाँ पर कह रहे हैं that in all civil proceedings the parties to the suit shall be competent witnesses. Means if A wants to become a witness and give evidence in his own favor, then he can do so in a civil proceeding. And if B as a defendant wants to give witness and give evidence in his own favor, that also be allowed. And that is provided in Order 18 Rule 3A of the CPC. Order 18 Rule 3A of the CPC as well. And in the other part it is saying in all civil proceedings the parties to the suit and the husband or wife of any party to the suit shall be competent witnesses. Now this suit, suppose suit is between the civil suit is between A and B. Now suppose A is a lady and इसका husband है H और इसकी wife है B की wife है suppose he is a man W. Now can the H be a competent witness for A or against A, or can W be the competent witness for B or against B? Now this declaration says yes. तो अब अगर आप पार्टी हो तो विटनेस बन सकते हो, और अगर आप किसी पार्टी के हस्बैंड और वाइफ हो तब भी आप विटनेस बन सकते हो इन द सिविल सूट. अब इन द क्रिमिनल प्रोसीडिंग्स दे आर सेइंग in criminal proceedings against any person, the husband or wife of such person respectively shall be a competent witness. In criminal proceedings against any person, the husband or wife of such person respectively shall be a competent witness. When criminal proceedings against any person means, suppose H is an accused in a case, so the criminal proceeding is against H. Criminal proceeding is against H. They are saying the husband or wife of such person respectively shall be a competent witness. Means H की wife W, if she wants to give evidence in favor of H or maybe against H, so can she become a witness? Answer is yes, and vice versa. Suppose if W is the accused, then H can be a witness for W or against W. अब ये witness बनने में problem नहीं है. Between husband and wife, husband can be a witness for the wife against the wife and vice versa. But 122 is saying that you cannot give the evidence of the communication that your husband has made or wife has made. ये तो ठीक है कि भाई W विटनेस बन सकती है H के फेवर में या H के खिलाफ, लेकिन H और W के बीच ड्यूरिंग द मैरिज कुछ कम्युनिकेशन हुआ था. H और W के बीच में ड्यूरिंग द मैरिज कुछ कम्युनिकेशन हुआ था, तो W कोर्ट में खड़े होकर H के परमिशन के बिना उस कम्युनिकेशन का एविडेंस नहीं दे सकती. अदर एविडेंस ही कैन गिव बट शी कैन नॉट गिव द एविडेंस ऑफ द कम्युनिकेशन. अब कम्युनिकेशन मीन्स व्हाट? अब हस्बैंड एंड वाइफ हैं तो दे आर कम्युनिकेटिंग विद each other so many things. Husband communicate with his wife and she communicate with husband and tell so many things. Now, husband and wife are so open to themselves, among themselves. So why they are so open? Because of their legal relationship and confidentiality. A wife will share everything to husband and say everything about herself, about someone else, because the wife is having the confidence in husband because of the marriage. तो ये जो आपस में हस्बैंड और वाइफ का कम्युनिकेशन होता है अबाउट देम सेल्फ और फॉर सम अदर पर्सन्स, अब ये जो बात करते हैं आपस में इतना फ्रीली बात क्यों करते हैं? बिकॉज दे आर हस्बैंड एंड वाइफ and there is a relationship of confidentiality, and the relationship of the husband and wife is based upon the mutual confidence, mutual trust and faith. Now if there is a doubt, if anyone is have either husband or wife, that if today he or she will tell something and tomorrow if the other one is having proceeding among themselves, sorry if today any one of them told the other something, and suppose husband tell wife about someone, and tomorrow if there is a proceeding filed against husband by someone, and the wife goes into the court and give the evidence that हाँ मुझे भी इसने ऐसा बोला था, तो मान लो हस्बैंड ने अपनी वाइफ को कह दिया कि दैट ए इज ऑफ बैड कैरेक्टर. अब ए found to come to know from someone and he files a suit against H, and W goes into the court and says yes I am the witness that he had said to me also. So is it not like that then the husband will share everything to wife and vice versa? So it will ultimately spoil the marital relationship because that is upon the mutual trust and faith. So section 122 is basically based upon this concept of mutual trust and faith in the marriages. If husband says something to wife, then the husband should be confident as per law that she cannot give the evidence of that in the court. She will not give the evidence of that in the court unless there is suit between the husband and wife. अब मान लो हस्बैंड एंड वाइफ के बीच में डिवोर्स पिटीशन हो गया, तो फिर जो जो हस्बैंड ने बोला जो जो वाइफ ने बोला सब बोलेंगे वो कोर्ट में आपस में. लेकिन अगर उनके बीच प्रोसीडिंग नहीं है, कोई क्रिमिनल प्रोसीडिंग नहीं है, अगर दोनों के बीच में कोई क्रिमिनल प्रोसीडिंग है, मान लो वाइफ ने हस्बैंड के ऊपर असॉल्ट के लिए सूट किया, केस किया, तब भी आपस के जो कम्युनिकेशन है फॉर दैट दे कैन गिव एविडेंस. बट सपोज if the suit is between the husband and some third person, or between the wife or some third person, so can the spouse go to the court and give evidence that my wife had said this or my husband had said this to me during the continuance of marriage? Answer is no. So that is what will made the trust and confidence into the marriage. हाँ, लेकिन ये जरूर है कि अगर आपस में हो जाए कोई प्रोसीडिंग हस्बैंड वाइफ में, देन यू शुड बी कॉशियस, क्योंकि अगर आपस में कभी भी इनका प्रोसीडिंग्स हो गया, देन देयर इज नो प्रिविलेज कम्युनिकेशन, everything can be told. So if the suit is between any of the spouse and a third person, then they cannot give the evidence for that if they are earlier communicated. But suppose if the suit is between H and W itself, then H can give evidence whatever he had said, whatever she had said, then H can give evidence whatever she had said, and wife can give evidence whatever he had said during the marriage. So that is the idea behind section 122. पढ़ लीजिए इसको. No person who is or has been married. No person who is or has been married. Is married means the presently the marriage is existing, or has been married means earlier he was married. पहले they were married. Earlier they were married. Now suppose they have taken divorce. No person who is or has been married shall be compelled to disclose any communication made to him. अब it could be him or her. अब him को her की तरह भी पढ़ोगे ना. Disclose any communication made to him during marriage by any person to whom he is or has been married. अब इसको देखकर तो लग रहा है कि बार सिर्फ हस्बैंड के ऊपर है, but it is upon wife also. अब ऑब्लिक लगा कर वो ही सी भी लिख सकते थे फॉर बोथ। तो नो पर्सन हु इज और हैज बीन मैरिड शैल बी कंपेल्ड टू डिस्क्लोज एनी कम्युनिकेशन मेड टू हिम ड्यूरिंग द मैरिज। और ड्यूरिंग द मैरिज मीन्स जो कम्युनिकेशन की बात हो रही है, जो कम्युनिकेशन की बात हो रही है वो तब हुआ होना चाहिए जब आपकी मैरिज एग्जिस्टिंग थी, ड्यूरिंग द मैरिज। शादी खत्म होने के बाद का कम्युनिकेशन इज नॉट फॉलिंग अंडर दिस। शादी जब तक चल रही थी तब तक का कम्युनिकेशन। Shall be compelled to disclose any communication made to him during the marriage by any person to whom he is or has been married, nor shall he be permitted to disclose। ना तो उसको आप कंपेल कर सकते हैं और ना ही उसको आप परमिशन दे सकते हैं टू डिस्क्लोज द फैक्ट unless the other party has agreed, nor shall he be permitted to disclose any such communication unless the person who made it or his representative in interest means other spouse consents except in suits between married persons or proceedings in which one married person is prosecuted for any crime committed against the other. Now if you say, if there is a suit between husband and wife, divorce petition or whatever, maintenance petition, or if there is a criminal proceedings initiated by one spouse against another, then in that case this privileged communication will not apply and you can give evidences against each other of the communications. But if they were married and there is a suit of one spouse or proceeding of one spouse with some other person, with third person, if there is a proceeding of one spouse with some other person, third person, then the other spouse cannot be permitted nor can be compelled to give the evidence for the husband or the wife of what the husband or wife said to her or him. But when the communication should have taken place during the marriage. For example, say suppose H and W, इनकी marriage हुई here and marriage is continuing. Now suppose here the H is in proceeding with brother-in-law. किसका brother-in-law? H का, H के साली साहब। उन्होंने प्रोसिक्यूशन किया H का, उन्होंने प्रोसिक्यूशन किया H का कि H ने मेरे बारे में उल्टा सीधा बोला है। H ने गुस्से में बोल दिया होगा अपने ब्रदर इन लॉ के बारे में वाइफ को। वाइफ ने बता दिया अपने भाई को कि उसने ऐसे ऐसे बोला है। ब्रदर इन लॉ ने सूट कर दिया। अब यहाँ पर इन दिस सूट द मैरिज इज एग्जिस्टिंग, द कम्युनिकेशन इज मेड बाई H to W will be on this date during the marriage continuation, during the continuation of the marriage. Now can W appear into the court? Can W appear in the court in favor of her brother to give evidence against H? That look, that my husband said this to me regarding her brother. The answer is no. Why? Because that communication is made during the continuation of the marriage. So if you read that carefully, no person who is or has been married, no person who is or has been married shall be compelled to disclose any communication made to him during marriage. During marriage means communication कब हुआ होना चाहिए? During the continuance of the marriage, during the marriage, by any person to whom he is or has been married, nor shall he be permitted to disclose any such communication unless the person who made it or his representative in an interest. If the person who made it is dead, the spouse who made it is dead, तो उसका representative in an interest, उसका consent होना चाहिए। अब here you see the communication made by H to W during the continuation of the marriage, and suppose the proceedings has also been filed by this third person against H during the continuation of the marriage. अब प्रोसीडिंग कब फाइल हुआ उससे कोई फर्क नहीं पड़ता, प्रोसीडिंग मैरिज खत्म होने के बाद भी हो सकता है, फाइल हो सकता है, उससे फर्क नहीं पड़ता। तो लेकिन मैंने एग्जाम्पल लिया है ड्यूरिंग द मैरिज का। अब कैन डब्ल्यू गिव एविडेंस इन द कोर्ट दैट माई हस्बैंड हैड said so and so to me during the continuation of the marriage against my brother? So the answer is no. अब इसी को थोड़ा चेंज कर देते हैं, सेम एग्जांपल। सपोज एच एंड डब्ल्यू गेट मैरिड हेयर। अब समवेयर हेयर सपोज ड्यूरिंग द कंटिन्यूएंस ऑफ मैरिज एच said something wrong to W regarding her brother or regarding her father and thereafter they had got divorced. अब डिवोर्स में जब एच एंड डब्ल्यू के बीच में डिवोर्स प्रोसीडिंग चला, जब उनके बीच डिवोर्स पिटीशन चला, तब तो कैन डब्ल्यू कैन गिव एविडेंस कि दैट हस्बैंड सेड रिगार्डिंग माय फादर, माय ब्रदर, फॉर माय ब्रदर एक्सेट्रा, शी कैन गिव बिकॉज इट इज द proceeding between husband and wife, and while proceeding is between them, the privileged communication will not apply. Now suppose they had got divorced. If they got divorced, of suppose somewhere here this brother got proceedings filed against H for what? For defamation. That he had said this to me. He had said regarding me to my sister. अब एट दिस स्टेज डिवोर्स हो चुका है, मैरिज खत्म हो चुका है। अब अर्लियर जो एग्जांपल दिया था दैट वाज द कंटिन्यूएशन ऑफ मैरिज, मैरिज के कंटिन्यूएंस के दौरान, लेकिन इस एग्जांपल में मैरिज खत्म होने के बाद ये प्रोसीडिंग से स्टार्ट करिए थर्ड पार्टी ने एच पर। अब ये जो ब्रदर इन लॉ है ये सूट फाइल करता है अगेंस्ट द हस्बैंड फॉर क्लेमिंग डैमेजेस ऑफ डिफेमेशन दैट एच हैज डिफेम्ड मी बाय सेइंग so and so to my sister about me. Now, if the statement was made by H during the continuation of the marriage, then W is not appear in to the court and give evidence against his husband. And the reason is that the communication is made during the continuation of the marriage. लेकिन मान लो डिवोर्स होने के बाद, एक दिन डिवोर्स होने के बाद एच ने गुस्से में आकर डब्ल्यू को फोन किया और खूब उल्टा सीधा सुनाया अबाउट हिज ब्रदर और फैमिली मेंबर्स आफ्टर द डिवोर्स। अब कैन द डब्ल्यू अपीयर्स इनटू द कोर्ट एंड गिव द एविडेंस फॉर दिस कम्युनिकेशन? आंसर इज यस। मीन्स द कम्युनिकेशन शुड हैव बीन मेड ड्यूरिंग द कंटिन्यूएशन ऑफ द मैरिज एंड एविडेंस ऑफ दैट विल बी प्रिविलेज्ड not only during the continuation of the marriage, even if the marriage is dissolved, thereafter also the privileged communication ka bar will apply if the communication is made during the continuation of the marriage. लेकिन अगर मैरिज डिसॉल्व होने के बाद अगर आपने कोई कम्युनिकेशन किया है then that will not be barred. प्लस अगर मैरिज कंटिन्यूएशन के बीच में आपने कोई स्टेटमेंट किया है और स्पाउसेस के बीच में प्रोसीडिंग्स हो जाए, देन आल्सो द कम्युनिकेशन इज नॉट बार्ड टू बी प्रूव्ड। तो ये 3 पॉइंट समझ में आया आपको? पहला, दैट द कम्युनिकेशन शुड बी मेड ड्यूरिंग द कंटिन्यूएशन ऑफ द मैरिज। देन डिड यू अंडरस्टैंड दैट द सूट एंड प्रोसीडिंग शैल टेक प्लेस विथ सम थर्ड पर्सन during the continuation of marriage or even after the dissolution of the marriage, but the communication should have been made during the continuation of the marriage. So for that the evidence cannot be given. But if after the continuation of the marriage, means after the dissolution of the marriage, if the communication was made and now one of the spouses wants to give the evidence of that, then will it be allowed after the dissolution of the marriage? कम्युनिकेशन आफ्टर द डिसोल्यूशन होता है, क्योंकि अब तो वो हस्बैंड वाइफ है ही नहीं, अब वो हस्बैंड वाइफ है नहीं तो ये सेक्शन लगेगा नहीं। अब एक और बात है दैट शुड इट बी अ लॉफुल मैरिज, शुड इट बी अ लॉफुल मैरिज। अब देखो फॉर दिस देयर इज नो जजमेंट, बट व्हाट आई थिंक इज इसको आपको थोड़ा लिबरल पढ़ना पड़ेगा। तो लॉफुल मैरिज हो या फिर वॉइडेबल मैरिज हो और या फिर वॉइड मैरिज भी है लेकिन हस्बैंड वाइफ की तरह रह रहे हैं, तो वहाँ पर भी ये प्रिविलेज कम्युनिकेशन लगना चाहिए, बिकॉज आपस का कम्युनिकेशन तो म्यूचुअल फेथ पर ही कर रहे हैं। दे आर डूइंग दिस कम्युनिकेशन ऑन द म्यूचुअल फेथ ओनली, एंड देयरफॉर इन माय ओपिनियन even if the marriage is not lawful, but they are living together as a husband and wife, and they had performed the marriage ceremony. Even if the marriage is void, then also as long as the marriage is not declared void, their communication should fall into the privileged communication. Now, suppose during the divorce petition, if the wife says that my husband says so and so about my brother, during the divorce petition, the wife says that regarding my brother, husband says so and so thing. Means he had done cruelty to me, and therefore I want divorce. Of this statement of the wife in the court, can the brother later on, when he files the suit for defamation, can he use can he use the statement of the sister which she had made in the divorce petition? Answer is no, because that statement उस स्टेटमेंट को प्रूव करने के लिए सिस्टर को कोर्ट में बुलाना पड़ेगा, और जब कोर्ट में आएगी सिस्टर, then the privileged communication will apply. Now write down upon section 122. Section 122 is based upon the policy of conserving the mutual confidence and trust in the marriage, and therefore if any communication was made by husband to wife or wife to the husband during the continuance of such marriage, the communication is privileged, and therefore in the suit or proceeding in which the husband or wife is involved with some third person, the evidence of such person cannot be given by the other spouse. The evidence of such person cannot be given by other spouse. It is essential that the communication was made during the continuance of marriage, and the prohibition applies upon the suit. The prohibition applies upon the suit or proceeding. अब इसमें एक करेक्शन कर लो आप. The evidence of such communication, ये पर्सन लिखा था उसको कट करके, the evidence of such communication cannot be given by the other spouse. It is essential that the communication was made during the continuance of marriage. It is essential that the communication was made during the continuance of marriage, and the prohibition applies upon the suit or proceeding. Prohibition applies upon the suit or proceeding initiated not only during the continuance of marriage, rather also if it was initiated after the dissolution of marriage. Means what? मतलब जो बार किस बात का है कि आपने जो शादी के दौरान कम्युनिकेशन किया था, तो उसका आप एविडेंस नहीं दे सकते हो. अब ये बार सिर्फ शादी के दौरान के लिए नहीं है, जो सूट और प्रोसीडिंग शादी के दौरान हुई है सिर्फ उसका नहीं है, बल्कि जो शादी के बाद भी अगर कोई सूट और प्रोसीडिंग होता है तब भी आप एविडेंस नहीं दे सकते, प्रोवाइडेड वो कम्युनिकेशन आपसे जो किया गया था ड्यूरिंग द कंटिन्यूएशन ऑफ द मैरिज, प्रोवाइडेड द communication was done during the continuation of the marriage. Next paragraph. However, the bar will not apply if the suit or proceeding was directly between the husband and wife. One last point you have to understand is, एक एग्जाम्पल से समझते हैं इस पॉइंट को. मान लो H and W get married here, and the marriage continues. Now during the continuance of marriage, due to some reasons wife left the house, and now wife is living in father's house after leaving the husband's house. While wife is living in father's house, on this date H wrote a letter to W. Now H wrote rubbish about her father. H wrote rubbish about her father of W, or the father-in-law of H. अब वाइफ ने लेटर पढ़ लिया, and after that she kept the letter into the drawer. Now suppose father-in-law get that letter from drawer and he got the letter. He took away the letter. He read it and took away the letter. मतलब अब वो लेटर किसके पास है? एच के फादर इन लॉ के पास या फिर फादर ऑफ डब्ल्यू. अब उसके बाद somewhere here father in law files a suit against H or maybe criminal proceeding also for defamation. तो कहानी ये है कि हस्बैंड वाइफ हैं. वाइफ अलग चली गई अपने फादर के घर पर. फिर हस्बैंड ने एक लेटर लिखा वाइफ को जिसमें उसने अपने फादर इन लॉ के खिलाफ बहुत कुछ उल्टा सीधा लिखा. अब वो लेटर फादर इन लॉ को मिल गया. नाउ द लेटर इज विद द फादर इन लॉ. अब ही फाइल्स अ सूट अगेंस्ट द दामाद फॉर द डिफेमेशन. ही फाइल्स अ सूट ऑफ डिफेमेशन अगेंस्ट द दामाद. मतलब एच सन इन लॉ. अब उसने अपने सन इन लॉ के खिलाफ सूट कर दिया. अब आपसे सवाल है उस डिफेमेशन सूट में एज एन एविडेंस F produces a letter. As an evidence, he produces a letter that this is the letter written by my son-in-law to my daughter, and this is how he has defamed me. Now, will the letter be admissible? Now, what is the answer? Answer is yes. Why? Answer is yes. The letter can be proved, but why? अब देखो ये जो बार है सेक्शन 122 में, if you look at the language, no person who is or has been married shall be compelled to disclose. So it is the person, the husband or wife, shall be compelled to disclose. Disclose means what? कोर्ट में जाकर आप डॉक्यूमेंट प्रोड्यूस करो खुद से, या फिर कोर्ट में जाकर किसी को ओरल एविडेंस दो कि मेरे हस्बैंड ने ये कहा है. So if the wife here herself goes to the court and tells the court that my husband had said so and so to me, or this is the letter that he has written to me. If she produces that evidence, no, then that will not be allowed. The bar is upon the spouse who is appearing in the court and giving evidence. But if a third person comes to know about it and he gave the evidence, even though the communication is between the husband and the wife. Now suppose the husband went to the house of the father-in-law and there he starts shouting upon his wife and saying all rubbish to her about her father. And suppose father-in-law heard everything. तो अब कोर्ट में बयान कौन देगा that he said this to his wife? Father देगा. So now father gives the evidence. If the father gives the evidence, then there is no bar upon it. The bar is upon the spouse only. So the spouse cannot go to the court to give the oral evidence or the documentary evidence. But if a third person comes to know about the communication, then the bar is not upon him. Now here who is giving the evidence? The father-in-law is giving the evidence and is the third person who is giving the evidence of the letter. Even though the communication is between the husband and wife, but when he obtained the letter, maybe wife herself gave the letter to the father और उसने बोला कि देखिए आपका दामाद कैसा है. So she gave the letter to him. Still, because ultimately the letter is in the hands of the father now. So therefore he can always give the evidence of the letter or the communication. But the spouse cannot give the evidence. So the bar is upon the spouse giving the evidence into the court and not upon the person who comes to know about the communication. Communication. So is that fine? तो इस पे एक केस लिख लीजिए आप. MC वर्गीज वर्सेस TJ पूनम 1968 सुप्रीम कोर्ट. तो ये अब जो फैक्ट्स मैंने बताए दैट इज फ्रॉम दिस केस ओनली. राइट डाउन. It was held that the bar is not upon a third person who has any proof of that communication. A third person can always appear in the court and give evidence of the communication between husband and wife if he can independently prove that communication. If he can independently prove that communication. However, if he wants to prove the communication by presenting one of the spouses in the court to give oral evidence, or by making one of the spouses to present documentary evidence in the court, then bar will apply. खुद करेगा डॉक्यूमेंट्री एविडेंस तो प्रॉब्लम नहीं है, लेकिन अगर स्पाउस को बोलेगा तुम डॉक्यूमेंट्री एविडेंस प्रूव करो, प्रोड्यूस करो, देन द बार विल अप्लाई। तो अगर उसने डॉक्यूमेंट्री एविडेंस थर्ड पर्सन को दे दिया स्पाउस ने और वो उसको प्रेजेंट करे तब बार नहीं है, लेकिन अगर ये स्पाउस जाके अगर प्रेजेंट करे या फिर स्पाउस जाके ओरल एविडेंस दे, देन द बार विल अप्लाई। अब मान लो एच और डब्ल्यू है, वो बात कर रहे हैं, एक्स कोई सर्वेंट उसने सुन लिया एंड एच इज गिविंग डिफेमेटरी स्टेटमेंट्स टू डब्ल्यू अबाउट सम ए। अब ए ने सू कर दिया एच को एंड एक्स ने बता दिया ए को, ए ने सू कर दिया एच को। अब एक्स वेंट टू द कोर्ट एंड टू प्रूव द or to give the evidence that what H has said. So he is not barred because he is the third person. But if W wants to go to the court and give the evidence against H, then that is barred because that is the privileged communication to spouse. And अब ये लेटर का एग्जाम्पल लिया है हमने, but it can be a chat of WhatsApp, Facebook, fax, anything like of this letter instead of letter, तो और भी चीज हो सकती है। नाउ सी सेक्शन 126, इसमें भी उसी तरीके से है that the lawyer and client is having the confidential relationship. अब suppose a person committed a crime and you are his lawyer, he engaged you as a lawyer and he tell you, in fact he admit before you that he has done a crime and in so and so manner, all that. So he speaks all the things that I have done a crime, please defend me. Now suppose tomorrow you stand into the court on his behalf and you turn back and you tell the court that no, he is admitted and he has admitted that he has committed the crime. You tell this into the court. Now will it be allowed to prove that? So here also again the point is that the accused told you that because he trusted you, because you are the person to defend him. मान लो लॉयर ने पूछा, तुमने पूछा उससे कि अच्छा सच सच बताओ कि क्या तुमने क्राइम किया था। तो अब ये जो उसने बोला कि किया तो था, उसने लॉयर ने उस चीज़ को रिकॉर्ड कर लिया और उसने जाकर कोर्ट में बोल दिया कि मान लो मैं तो इंसाफ चाहता हूँ, सच्चाई के साथ ही हूँ और मैं अन्याय नहीं होने दूंगा और इसने क्राइम किया, इसको सजा दिया जाए। So will he allowed to do? Similarly, suppose when the accused came to you, then while narrating everything, discussing, then he showed several given documents to you and admitted that he has committed crime. And ultimately the lawyer refused to take his case. Lawyer says that no, I will not take your case. You have done a wrong act. I will not take up your case. So the meeting was there, but he never took his case, accused's case. Now can he communicate the fact that the accused has communicated with the lawyer into the court? Can the lawyer say that into the court? Now here also, बेशक आपका वो लॉयर बना या नहीं बना, लेकिन आपने ट्रस्ट और फेथ में उसको कम्युनिकेट किया. Ultimately, he has not taken the case, but still the privileged communication will apply. And this will apply not only to the lawyer, but when we are talking to the lawyer, then it also covers Munshi, his clerk, his peon, junior lawyer. So the privileged communication will apply to them also. But suppose the third person who was sitting, who is not related to his office, some third person, maybe some other client was sitting, and he was heard whatever he was telling to his lawyer, then the privileged communication will not apply to him. मतलब लॉयर अगर बैठा है उससे साथ कोई डिस्कस कर रहा है, उसका स्टाफ बैठा है, उन्होंने सुन लिया तो प्रिविलेज कम्युनिकेशन लगेगा, सो दे कैन नॉट गिव द एविडेंस। लेकिन मान लो उसी लॉयर का कोई दूसरा क्लाइंट या थर्ड पर्सन बैठा है जो कि उसका स्टाफ नहीं है, तो फिर उसके ऊपर वह प्रिविलेज कम्युनिकेशन नहीं लगेगा। ही कैन ऑलवेज गिव द एविडेंस। सो इट इज अ मैटर ऑफ कॉशन फॉर द एडवोकेट्स that never allow a third person when you are dealing with one client, because he can give the evidence into the court. So lawyer cannot, his staff cannot, junior lawyers, clerk, peon, they cannot. But the third person, when he comes to know about it, the privileged communication does not apply upon him. So read it. No barrister, attorney, pleader or vakil shall at any time be permitted unless with his client's express consent. अब client express consent दे देता हो तो ठीक है, unless with his client's express consent to disclose any communication made to him in the course and for the purpose of his employment as such barrister, pleader, attorney और वकील etc. मतलब जब आपने उसको एम्प्लॉय करने के लिए या एम्प्लॉय करने के बाद उस एम्प्लॉयमेंट के पर्पस से अगर कम्युनिकेशन किया है, बहुत ध्यान से सुनिएगा इसको, दिस इज वेरी इंपॉर्टेंट सेक्शन। यू आर मेड द कम्युनिकेशन टू हिम either for the purpose of and in the course of employing him, maybe ultimately you cannot be employed him, or you already employed him and for the purpose of that employment, that engagement, he had made the disclosure to you, then in that case the lawyer will be bound by this section and he cannot give the evidence of the communication in the court. Read it again. No barrister, attorney, pleader or vakil shall at any time be permitted unless with his client's express consent to disclose any communication made to him in the course and for the purpose of his employment as such barrister, pleader, attorney or vakil by or on behalf of his client, or to state the contents or condition of any document with which he has become acquainted in the course and for the purpose of his professional employment, or to disclose any advice given by him to his client in the course and for the purpose of such employment. अब ये in the course and for the purpose is very important। मतलब आपने कब दिया स्टेटमेंट या कब उसको डॉक्यूमेंट दिए, इन द कोर्स ऑफ एम्प्लॉयमेंट, और किस वजह से दिया, फॉर द पर्पज ऑफ his defending the case. Now he ultimately going to employ you or not, that is not the issue. The issue is that while you are trying to employ him, while the accused is trying to employ the lawyer in the course of that process, means for the purpose of defending process plus for the purpose of defending process, you stated something to him or you gave some documents to him or showed some documents to him and he became familiar with that such facts, or maybe he engaged you and after engaging you he has made those statements or given the documents. So if that is the case, so neither the document and nor any statement made by the client can be given as an evidence, even if the client had not engaged lawyer, उसने मना कर दिया कि मान लो फीस ज़्यादा है आपकी, तो उसने मना कर दिया और या फिर आपने मना कर दिया, लॉयर ने मना कर दिया, सो स्टिल ही कैन नॉट गिव द एविडेंस ऑफ दोज फैक्ट्स। इफ द क्लाइंट रिफ्यूज देन ऑल्सो द लॉयर कैन नॉट गिव एविडेंस ऑन दैट, neither of the document nor the statement that is made by the client. And if the client engaged him, then also the lawyer cannot give the evidence of that. But till when? It is till forever. It is forever. ये नहीं है कि जब क्लाइंट और वकील का रिलेशनशिप खत्म हो जाएगा उसके बाद वो एविडेंस दे सकता है। ये हमेशा के लिए प्रिविलेज्ड कम्युनिकेशन रहेगा उन दोनों के बीच। वकील नेवर गिव the evidence against the client unless he has given the client has given the express consent for that, and there has to be an express consent. Implied consent नहीं माना जाएगा इसके लिए. Now proviso, provided that nothing in this section shall protect from disclosure. Provided that nothing in this section shall protect from disclosure. अब दो exceptions हैं. अगर ये दो exceptions में matter fall कर गया, then the evidence can be given. Number one, any such communication made in furtherance of any illegal purpose. What do you mean by that? अब देखो, पहले जो तुमने कर दिया है उसका अगर कम्युनिकेशन करते हो तो वो तो प्रिविलेज होगा, लेकिन अब अगर तुम कहते हो, जैसे कहते हो कि वकील साहब ये कल हियरिंग है, वकील साहब ने कहा कि तो कल हियरिंग है, विटनेस आएगा, मुझे उसको क्रॉस एग्जामिन करना है, तो आपसे मुझे कुछ डिस्कस करना है उस बारे में. तो आपने बोला वकील साहब चिंता मत करो, उसको मैंने उड़ा दिया, विटनेस मर गया है, तो क्रॉस एग्जामिनेशन की ज़रूरत ही नहीं है तैयारी की. तो जो आपने वकील को बताया कि मे बी आई हैव किल्ड, ये बताया, या फिर आपने डरा दिया उसको, आई हैव थ्रेटन्ड द विटनेस, यू विल गो टू द कोर्ट. सो हियर दिस इज एन इलीगल एक्ट दैट ही हैज डन आफ्टर द एंगेजमेंट. दिस इज एन इलीगल एक्ट ही हैज डन आफ्टर द एंगेजमेंट, and he has communicated this to vakil, or otherwise the vakil came to know from somewhere about that. So इस पर privileged communication will not apply. Now any wrong you have done, the accused has done before engaging the vakil, so on that communication the privileged communication will apply. On that communication the privileged communication will apply, but after engaging the vakil, or in the course of engaging him, the client has done some illegal act. Maybe the client forged some document. Maybe the client threatened some witness. Whatever wrong the client has do, then on that the privileged communication will not apply. फिर से बोल रहा हूँ. In the course of engaging him, or after engaging him, if the accused has done, or the client has done the illegal act, maybe forging document, threaten witness, fabricate the evidence. So any such illegal act that the vakil comes to know, either the client tell to vakil of that, or the vakil himself comes to know, then that will not fall into the privileged communication, and the lawyer or vakil can always give the evidence of that. So the logic is that you will not support something illegal. अब जो चलो पहले का जो मैटर था देन वो तो आप करोगे, तो उस पर तो प्रिविलेज्ड कम्युनिकेशन विल अप्लाई. लेकिन अगर एंगेजमेंट के बाद अगर क्लाइंट इलीगल एक्ट करता है, देन देयर दिस सेक्शन विल नॉट अप्लाई. So provided that nothing in this section shall protect from disclosure any such communication made in furtherance of any illegal purpose, any fact observed by any barrister, pleader, attorney or vakil in the course of his employment as such, showing that any crime or fraud has been committed since the commencement of his employment. मतलब जब से इसने मुझे एंगेज किया है उसके बाद इसने कोई क्राइम या फ्रॉड किया है, उस केस से रिलेटेड उस पर फिर प्रिविलेज्ड कम्युनिकेशन नहीं लगेगा. एंड आई टोल्ड यू दैट इफ यू टेल हिम अबाउट दैट रॉन्ग, दैट आई हैव डन दिस नाउ आफ्टर द एंगेजमेंट, or he himself comes to know about it, so either ways privileged communication will not apply. लेकिन एंगेजमेंट के पहले का जो भी क्राइम किया है तो उस पर प्रिविलेज्ड कम्युनिकेशन लगेगा. एंगेजमेंट के पहले अगर कोई क्राइम किया है तब उस पर प्रिविलेज्ड कम्युनिकेशन लगेगा. It is immaterial whether the attention of such barrister, pleader, attorney or vakil was or was not directed to such fact by or on behalf of his client. It is immaterial whether the attention of such barrister, pleader, attorney or vakil was or was not directed to such fact. What fact? ये proviso वाले facts. Proviso वाले facts मतलब the illegal things he has done after the engagement. उस पर अब जैसे विटनेस के क्रॉस एग्जामिनेशन के लिए आपने बोला वकील साहब जाओ, आप क्रॉस एग्जामिनेशन की जरूरत नहीं पड़ेगी, मैंने विटनेस को उड़ा दिया, तो आपने खुद वकील साहब को बताया तब भी प्रिविलेज्ड कम्युनिकेशन नहीं लगेगा. या फिर वकील साहब को, वकील साहब ने खुद ऑब्जर्व कर लिया, उनको पता चल गया कि आपने ऐसा किया है, तब भी प्रिविलेज्ड कम्युनिकेशन नहीं लगेगा। देन एक्सप्लेनेशन, द ऑब्लिगेशन स्टेटेड in this section continues after the employment has ceased. So that I already told you. So unless you give the consent, client gives the consent, the lawyer cannot give the evidence of the fact. And if he gives the evidence, then that will be not allowed. So is that fine? बाकी के चीज़ थी वो आपको शुरू में बता दी कि ये प्रिविलेज्ड कम्युनिकेशन किस पे लगेगा, सिर्फ लॉयर पे नहीं, उसके ऑफिस स्टाफ पर भी लगेगा। लेकिन अगर कोई थर्ड पर्सन बैठा है वहाँ पर जो उसका ऑफिस स्टाफ नहीं है, अगर उसने सुन लिया या उसने देख लिया, तो फिर प्रिविलेज्ड कम्युनिकेशन उस पर नहीं लगेगा, थर्ड पर्सन पर प्रिविलेज्ड कम्युनिकेशन नहीं लगेगा जो अदर देन ऑफिस स्टाफ कोई बैठा है तो। So he can always give evidence. And I also told you that even after the case is over, then also the privileged communication will apply, and the bar will apply even after the client has died. अगर क्लाइंट मर भी गया तो उसके बाद भी बार लगेगा। अब मान लो आई हैव अ फ्रेंड who is a lawyer and I happen to meet you somewhere and I tell him that yaar I have done this wrong, what should I do? Now I am not discussing this thing with him for the purpose of engaging him, though as a lawyer I am discussing him as a friend. Or did the privilege communication apply? No. तो सिर्फ इस वजह से कि वो लॉयर है प्रिविलेज कम्युनिकेशन नहीं लग जाएगा। प्रिविलेज कम्युनिकेशन सिर्फ जब लगेगा जब आपने उसको एंगेज किया है या एंगेज करने के लिए मीटिंग कर रहे हो, देन द प्रिविलेज कम्युनिकेशन विल अप्लाई। लेकिन सिंपली जनरली अब जो भी स्टूडेंट्स हैं, ये लॉ स्टूडेंट्स हैं, वो सारे लॉयर्स, अगर रजिस्ट्रेशन करा लिया तो लॉयर्स होंगे, तो कुछ हो गए हैं या फिर कुछ हो जाएंगे। तो आप आपस में अगर कोई डिस्कस कर रहे हैं कि यार कोई गलती हो गई, आज मैंने ऐसा कर दिया, अब दूसरा वाला पहुंच गया आपके खिलाफ बयान देने के लिए कोर्ट में, अब विल द प्रिविलेज कम्युनिकेशन विल अप्लाई इन दिस केस? नो। अब you can always tell into the court that no, I was telling him because I want to engage him as a lawyer. That is a different thing. But otherwise, if you are not trying to engage him or her, then in that case the privilege communication will not apply, even if you made a communication to a lawyer, if you are not communicated him for the purpose of engaging him. कोई फैमिली फ्रेंड है, अगर उसको आपने बताया तो उसके ऊपर प्रिविलेज्ड कम्युनिकेशन नहीं लगेगा। अब इसमें इलस्ट्रेशन देख लेते हैं। A client says to B is a lawyer. A client says to B, I have committed forgery and I wish you to defend me. अब बताइए लगेगा कि नहीं लगेगा प्रिविलेज्ड कम्युनिकेशन? आंसर इज यस। As the defense of a man known to be guilty is not a criminal purpose, this communication is protected from disclosure. Illustration B. A client says to B, a lawyer, I wish to obtain possession of property by the use of forged deed on which I request you to sue. अब बताइए, this is the communication in furtherance of the criminal purpose, क्योंकि वो फॉर्ज डीड लगाकर प्रॉपर्टी ऑब्टेन करना चाहता है और वकील से कहता है क्या तुम उस फॉर्ज डीड को लगाकर मेरा कोर्ट में केस फाइल करोगे? अब this is fall in the proviso, therefore no privileged communication. So illustration C you read yourself. That's it for this section and this lecture. Thank you.